together and try to come up with a resolution. Yeah?
With 3 people, does it have to be a unanimous decision?
Yes. But here's the thing. So you name all your kids. Unless you can sell me on a reason why you should name all your kids. If one kid's on drugs, if one kid's estranged and you haven't seen him for 20 years, if one kid is special needs, has some kind of physical or mental challenge that actually directly impacts on his or her ability to understand and sign documents, I need to be sold. Or if you have 12 kids, you're not going to name all 12. That's a lot. So but the question is, do you need all 3? Yes, you need all 3. And so the question is, well, what happens if somebody throws a monkey wrench in the works just out of some family baggage that arose years ago that hasn't been resolved, and someone's going to just completely cut off their nose to spite their face and not sign and not cooperate? My response is this. In 30 years of dealing with multiple trustees after the deaths of clients, after the deaths of both mom and dad, only one time have I seen the pre-existing family baggage do damage to the administration and distribution of the trust. Those were 3 sisters, and they spent more money on lawyers' fees to divide worthless personal property than what the property was worth. I mean, that was a rare, that's what cinema is made of, that kind of situation. Boy, the lawyers got rich on that because they didn't care, it was like, while Rome burns, there's some other analogy that I can come up with, I just can't remember. But anyway, remember that movie Wall Street where Gecko says greed is good? Greed works, and in the inheritance context, greed does work, because even the most recalcitrant, wrench-throwing trustee sibling is going to realize the more noise I make, the more that's going to delay me getting my share, and the more that's going to lessen my share. The more noise that's going to diminish my share in attorney's fees and all that. So it's because of that even the kids who never got along, if your kids couldn't share their toys, how are they going to manage or carry out the inheritance? They're going to do just fine because everybody wants their share. That's the reality. I understand the potential problem, that there's going to be some spite. But that spite is overcome by, I would like my share sooner than later and to its fullest extent. Okay. So name all your kids as trustees in order for your plan to do no harm. To do no harm. Okay. There's a number of other situations in the do no harm category that I'm talking about, but I want to move on. And I'm talking about the right type of instructions that you're going to have in your living trust. And the right type of instructions say, in addition to making sure that your kids perceive that they've been treated fairly, is to make sure that the money and property that you leave them is not subject to their risks of loss in life. There's a whole laundry list of problems that your kids have that could cause loss and diminishment to their inheritance. You have to realize that while you're alive, of course you own your money and property. But sometimes people have a hard time seeing beyond the death horizon. And they forget something that's really obvious, which is after you die, you don't own it anymore. It goes to your kids. Now what? It's in your kids' hands. So what can happen? A lot can happen. They can lose it to financial immaturity. They can lose it to their spouses in a divorce or remarriage. They can lose it to drug addiction, alcohol, crazy cults, mandatory tithing to charity. They could be professionals and have a malpractice action and have insufficient malpractice insurance. They could be in an auto accident or a health problem. As you're sitting here, you do not intend for the assets that you leave to your kids to just be dwindled through their fingers with their problems in life. That's not why you work 50, 60 years of your life to accumulate wealth or whatever it is that you own. You want to be sure that when you're gone, or at least you want to die knowing, because there's a comfort to this, you want to die knowing that the assets that you leave to your kids will be used for them for proper purposes so that it ultimately ends up with who? Your grandkids. It's kind of far afield. That's ultimately, if my dad was standing here, he'd say, I like Jeff, but I really love his kids. His kids are great. Jeff's just okay. And that's because that's who he wants ultimately to benefit from the estate. So that's what you have to think about. You have to think about the money and property that you leave to your kids has to be protected for them and from them. From them. So the right plan, the right instructions in your inheritance plan, in your living trust, say that you do not leave your children an outright inheritance. Do not leave it to them outright. Do not leave it to David outright, here you go, buy escondidos. You do not leave it to them outright. Outright is passé. Instead, you leave it to your child in what we call a protection trust. This protection trust builds a castle wall around their inherited shares. And this wall can be a really thin wall that offers some protection, or it can be a super thick wall that offers 105% protection. What am I talking about? There's different levels of protection. Just depends on the problem that you perceive that you tell me about. And the first problem you're going to tell me about is my kids have no problems. They're not subject to anything. They're not on drugs, they're not on alcohol, they're not homeless, and they get along great with their spouses. So we don't need anything. I'm going to go wrong. Here's what you need. You need to leave your share. You need to leave your, let's do son, your son's share to your son in a protection trust that offers no protection whatsoever. And this protection trust, your son is in charge, just like you're in charge of your living trust. In this protection trust, he gets the income, he gets the principal, he's the trustee, he can dip into it for anything he wants, or he can leave it to anybody he wants, he can give it to some guy walking down the street. Protection trust, right? I mean, what kind of protection is it? It gives you no protection, but it gives no real protection. But 99% of the trusts that I do have the inherited shares go to these children in, these problem-free children, these risks-free children in this type of protection trust. One client described it as a transparent trust. It's like not having a trust at all. But what it does is it gives your son ammunition to use against spousal pressure to place the assets in their joint names. And then what happens if they put it in their joint names? He dies first, she gets it all, she gets remarried, and the inheritance that you left to your son winds up with your ex-daughter-in-law, second husband's kids from his first marriage. Or there's a divorce, and your former daughter-in-law walks away with one half. That's not what you want. I know it. So what you want is to leave it to your son in protection trust so that it's like creating a living trust for your child. So that when that spousal pressure takes place, honey, darling, lover, we own all our other assets jointly. Why don't you put your inheritance in our joint names after all? It makes sense. And don't you love me? Don't you trust me? That's a lot of pressure. And what's the implication of saying no? No is I don't love you, I don't trust you. So the answer instead is Condon put together this plan, and this plan provides that I get it in trust, and that it needs to be retained as a separate property so that on my death it goes to the kids. And it's true. It's true. We have saved so many marriages as a result of this type of plan. This is the loving spouse protection plan. Not an evil spouse. Not an evil spouse. That's the next level of protection. If you tell me that you have a daughter and that she's married to a guy that every time you see him come walking into your house, you can see the dollar signs in his eyes because he's mentally sizing up everything that's going to be his after you die. And he's always saying, oh, when my ship comes in. And when the ship comes in is after your death. And you know that your son-in-law is going to be putting a lot of pressure on your daughter to give up a portion of her wealth. Okay, that's a daughter who may not be able to withstand that kind of pressure. So we need something more than the protection, than the transparent trust. We need the irrevocable protection trust, where you're still creating a sub-trust for your daughter, where she's the trustee, she gets the income, she gets the principal, she can do whatever you want her to do with it. Support, health, education, what have you. But it's irrevocable. It can't be changed. It can't be used for improper purposes. She is not allowed to give it away to anybody. and then on her death, it goes to her kids. Okay. And that way, she's still in charge. You wouldn't believe me. I've done this plan a number of times, and when the kids come in and I'm explaining around the table that your parents left it to you in trust for the rest of your life, they almost go apoplectic. They go, "What do you mean? Oh my God, I have to controlled by some third party. I have to go run to some third party every time I want to take money and go to Ralph's?" No, you're in charge. But the whole point of this, as I explained to them, is to ensure that you are not legally allowed to use it for improper purposes. What's an improper purpose? Giving it to your spouse. Who can you be held liable to if you give it to your spouse? You can be held liable to your kids, because it says that your kids get it on your death, and the remaindermen, and the income beneficiary, she's the trustee, so the trustee has fiduciary responsibilities to the remaindermen not to use it for improper purposes. Anyway, that's a lot. So we have just saved that inheritance from that lout of a son-in-law. And then the next level up is a third-party protection trust. This is when you have the kids on drugs, the financially immature child, the alcoholic child, the homeless child. You just know that as soon as that child receives his or her share, it's going to wind up with the drug dealer or the bankruptcy creditors. So now you have to appoint a third-party trustee for that child's share. By the way, when I'm talking about these sub-trusts, these protection trusts, I'm not talking about some separate document outside your living trust. These are the inheritance instructions that go inside your living trust. Okay. So this is very important. The right plan assumes that you know your kids better than I do, and that you are going to tell me what problems your kids have that the money and property could be subject to once in their hands. Okay. That's the protection trust. It's a term that my dad and I coined. I mean, these trusts have been around for a long time, but we came up with the term protection trust, and we've actually heard that used. And so we came up with the term, and we're not getting any royalties on it whatsoever. Okay. So let's see. What else is in a good inheritance plan? First